Thank you all for returning again after our first day of the trial. Before we get started, would each of you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Have each of you been able to follow my instructions over the course of the evening? That is, or over the course of the weekend. That is not to talk to anybody about this case, not to do any of your own research or homework on the parties or the people involved in this case. Yes. Thank you so very much. And I'll be asking you that each morning, so hopefully that will be the case. And no one's approached any of you to talk about this case during the course of the weekend? No. Great. Thank you. All right. So when we left off on Friday, you all had just taken an oath to serve as the jurors in this case. So before we begin, I wanted to give you some other instructions. It is my intention to give you an overview of the rules of law associated with the claims and the defenses in this case, but it might be that I will not know for sure all of the law that will apply in this case until all of the evidence is presented. However, I can anticipate most of the law and will give you an overview of it at the beginning of the trial so that you will better understand what to be looking for while the evidence is presented. If I later decide that different or additional law applies to this case, then I'll let you know at that time. In any event, at the end of the evidence, I will give you the final instructions on which you must base your verdict, including specific instructions governing the elements of each claim and defense. At that time, you will have a complete written set of all of the instructions, so you do not have to memorize what I'm about to tell you. If you'd like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take any notes if you do not want to individually. When you came in this morning on your chair, there's an envelope with instructions on the outside of the envelope. Inside the envelope are pad of paper and pens. So please, during the course, use that pad and pen for your notes. During recesses, please put them back in the envelope, leave them on the chair, and our deputy will collect your notes. At the end of the trial, you will have all of your notes with you when you go to deliberate. After you deliberate, after the conclusion of all of it, the deputy again will take your notes and I will immediately shred them. So no one will ever read your notes. Please don't be concerned about that. But I do want to let you know, if you do take notes, please do not get so involved in note-taking that you become distracted from the proceedings. Your notes should only serve as an aid to your memory, and whether or not you take notes, you should rely only on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Now, an overview of the claims, I'll now discuss each of the specific claims and defenses and define some of the terms that you will use in deciding this case. The plaintiff, Mr. Balea, has asserted 5 claims against the defendants. Each of these is a separate and independent claim which you will decide in this case. These claims are as follows. The plaintiff's first claim is for the invasion of privacy based upon the publication of private facts. That claim consists of the publication of truthful, private information that a reasonable person would find highly offensive and that does not relate to a matter of legitimate public concern. The plaintiff's second claim is for invasion of privacy based on intrusion upon seclusion. That claim consists of the wrongful intrusion through physical or electronic means into a place in which the plaintiff had a reasonable expectation of privacy in such a manner as to outrage or cause mental suffering, shame, or humiliation to a person of ordinary sensibilities. The plaintiff's third claim is for invasion of privacy based on misappropriation of the right of publicity. That claim consists of the unauthorized use of plaintiff's name or likeness for a commercial or advertising purpose. The plaintiff's fourth claim is for intentional infliction of emotional distress. That claim consists of extreme and outrageous conduct by a defendant that causes severe emotional distress and was engaged in either with an intent to cause severe emotional distress or a reckless disregard of the high probability that it would cause goes well beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in civilized community. Emotional distress is severe when it is of such intensity or duration. The plaintiff's fifth claim is for violation of Florida's Security and Communications Act. That claim consists of the disclosure of oral communications in which plaintiff had a reasonable expectation of privacy by one who knows or has reason to know that the communications were recorded without plaintiff's knowledge or consent. The defendants deny plaintiff's claim. Defendants contend that the video, in the context of the accompanying report and commentary, was protected by the First Amendment because it related to a matter of public concern. They also deny specific parts of the plaintiff's claims. For example, the defendants deny that they intruded physically or electronically into a private place. They also deny that they used plaintiff's name or likeness for a commercial or advertising purpose. They further maintain that plaintiff did not, in fact, suffer severe emotional distress as a result of their conduct, and they contend that they posted the video containing plaintiff's oral communications on Gawker.com in good faith reliance on a good faith determination that their conduct was lawful. The issue of legitimate public concern, or newsworthiness, is an element of plaintiff's claim for publication of private facts, as well as a First Amendment defense raised by the defendants to each of the plaintiff's claims. I will now define legitimate public concern. The right of privacy and the right of freedom of the press are both fundamental rights, which must be balanced. The right to privacy can be outweighed if a publication relates to matters of legitimate public concern. A matter of public concern is one that can be fairly considered as relating to any matter of political, social, or other concern to the community, or that is subject to a general interest and concern to the public. The mere fact that a publication contains arguably inappropriate conduct does not remove it from the realm of legitimate public interest. In weighing this issue, you should take into account the content, context, and form of the material at the time of the publication to determine whether it relates to a matter of public concern. The line between the right of privacy and the freedom of the press is drawn where the publication ceases to be the giving of information to which the public is entitled and becomes a morbid and sensational prying into the private lives for its own sake, with which a reasonable member of the public with decent standards would say that he or she had no concern. The parties must prove their respective claims and defenses by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Now that you have heard an overview of the claims and the defenses, I want to let you know what you can expect as the trial proceeds. In a few moments, the attorneys will each have a chance to make what are called opening statements. In an opening statement, an attorney is allowed to give you their views about what the evidence will be in the trial and what you are likely to see and hear in the testimony. After the attorney's opening statements, the plaintiffs will bring their witness and evidence to you. Evidence is the information that the law allows you to see and hear in deciding this case. Evidence includes the testimony of the witnesses, documents, and anything else that I instruct you to consider. A witness is a person who takes an oath to tell the truth and then answers the attorney's questions for the jury. The answering of attorney's questions by witnesses is called giving testimony. Testimony means statements that are made when someone has sworn an oath to tell the truth. The plaintiff's lawyer will normally ask the witness the questions first. That is called direct examination. Then the defense attorney may ask the same witness additional questions about whatever the witness has just testified to. That is called cross-examination, and then the plaintiff's lawyer will have an opportunity for redirect based on answering the same question, asking the same questions regarding what the witness just testified to. Certain documents or other evidence may also be shown to you during this phase of direct cross-examination and redirect. After the plaintiff's witnesses have all testified, the defense will have the opportunity to put their witnesses on the stand and go through the same process of direct cross-examination and redirect. The process is designed to be fair to both sides. It is important that you remember testimony comes from the witnesses. The attorneys do not give testimony, and they themselves are not witnesses. Sometimes the attorneys will disagree about the rules for trial procedure when a witness is asked a question. When that happens, one of the lawyers may make what is called an objection. The rules for a trial can be complicated, and there are many reasons for the attorneys to object. You should simply wait for me to decide how to proceed. Possible while you are giving us your very valuable time here in the courtroom. But if we do have to have such a conference during testimony, we will try to have the conference up here at the bench so that you don't have to take a break. Although sometimes if they sound like they're going a little longer, then I will ask the deputy to take you into your jury room. I think you all are familiar with your room now, so that you can take a break during that time. Breaks in an ongoing trial are usually called recesses. During a recess, you still have your duties as a juror, and you must follow the rules, even while you are in your break, at lunch, at home, anywhere else, in addition to this courtroom. After all of the evidence has been presented to you, I will instruct you in the law that you must follow. It is important that you remember these instructions to assist you in evaluating the final attorney presentations, which will come next, and later during your deliberations, to help you correctly sort through all of the evidence to reach your decisions. And again, you will each have a written copy of each of those with you, so you don't have to try and memorize them. The attorneys will then have the opportunity to make their final presentations to you, which are called closing arguments. After you've heard all of the closing arguments, I will then instruct you further on the law, as well as explain to you the procedures that you must follow to decide. After you hear the final jury instructions, you will then go to the jury and decide the questions that I put for you on a verdict form. The discussions that you have, the decisions that you make, are called jury deliberations. Your deliberations are absolutely private, and neither I nor will be posted outside your door to make sure that only you are the only ones in that room. Questions. You will give the verdict form to the deputy, and we will all return to the courtroom where your verdict will be read. When that is completed, not until the very end, will you be released from your assignment as a juror. So before we begin, I want to give you a few more brief explanation of the rules that you must follow as the case proceeds. Keep an open mind. You must pay close attention to the testimony and other evidence as it comes into the trial. However, you must avoid forming any final opinion or telling anyone else your views on the case until you begin your deliberations. This rule requires that you keep an open mind until you have heard all of the evidence, and it is designed to prevent you from influencing how your fellow jurors also think until they too have heard all of the evidence and had an opportunity to form their own opinions. The time and place for coming to your final opinions and speaking with your fellow jurors is during deliberations in the jury room. After all of the evidence has been presented, the closing arguments have been made by the lawyers, and I've instructed you on the law. It is important that you hear all of the facts and that you hear the law and how to apply the law to the facts before you start deciding anything. It is only the things that you see and hear in this courtroom that matter during this trial. You've now probably heard me say that 10 times, but that's true. The law tells us that a juror can consider only the evidence and the testimony that all of the other jurors have also heard and seen in the presence of me as the judge, the lawyers, and the parties. Doing anything else would be wrong and would be against the law. That means that you must not do any work or investigation on your own about this case. You must not obtain on your own any information about the case or about anyone involved in the case from any source whatsoever. This includes reading newspapers, watching television, or using a computer, the cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people or parties involved in this case. This applies whether you are here at the courthouse, at home, or anywhere else. Do not provide any information about this case to anyone, including family or friends. Do not let anyone, including the closest family members, make comments to you or ask have any discussions of any sort with friends or family members about the case or the people or parties involved. So please do not let even the closest family member make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, tablets, computers, or any other electronic device to communicate with anyone. Do not send or accept any messages related to this case or even about your jury service. If you don't like the temperature, talk to the deputy, not to anybody else about it. Please do not discuss this case or ask for advice by any means at all, and that includes posting information on any kind of internet website, chat room, or blog. Please do not follow any Twitters regarding this case. When we are in recess, please do not discuss anything about the trial or the case with each other or with anyone else. If attorneys or anyone else approach you, please do not speak with them. The law says they all can you all hear me? Yeah, okay. So please inform the deputy. If that deputy is not available, please just find any in the green uniform and they will all take care of it. Only you get to deliberate and answer the verdict questions at the end of the trial. I will not intrude into your deliberations at all. I am required to be neutral. You should not assume that I prefer one decision over another. You should not try to guess what my opinion is about any part of this case. It would be wrong for you to try to guess or conclude about my opinion or that anything that I say or do means that I am for one side or another during the trial. Discussing and deciding facts is your job alone. All cell phones or other types of electronic device must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recess, but even then you may not use your phone or electronic device to find out any information about this case or to communicate with anyone about the case or the people involved in this case. Please do not take any photographs, video recordings, or audio recordings of the proceedings or even of your fellow jurors. After each recess, please double check to make sure that your device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. This is at the end during jury deliberations. If there are breaks in your deliberations, I may allow you to communicate with your family or friends, just not about this particular case. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you immediately without any delay, and we will provide a phone number for you. During the trial, you may have a question about the proceedings. If so, please write it down, hand it to the deputy, who will hand it to me. I will review the question with the parties and their attorneys before responding to you about your answer. You also may have a question that you think should be asked of a witness. So if so, there is a way for you to request that I ask the witness a question. So after all of the attorneys have completed their question of the witnesses, the direct, the cross-examination, the redirect, at that time, if you still have a question, please raise your hand. I'll give you an opportunity to write the question down. So So write the question, give it to the deputy, who will pass it to me. Please do not put your name on the question or show it to anyone or discuss it with anyone else. At that time, I will review the question with the attorneys. Under the law, there are only certain evidence that may be considered by the jury to determine a verdict. And you are bound by the same rules of evidence that control the attorney. Witness. The attorneys may then ask follow-up questions if they wish. If there are additional questions from the jurors, then we will follow the same procedure until all of the questions have been answered. By providing this procedure, I do not mean to suggest that you must or that you even should submit written questions for witnesses. In most cases, the lawyers will have asked all the necessary. Clarify one point on my instructions. This was regarding legitimate public concern. The mere fact that a publication contains arguably inappropriate content does not remove it from the realm of legitimate public interest. Thank you. All right, so at this time, Mr. Vogt.
On October 4th of 2012, the defendants, Nick Denton, AJ Delaria, and Gawker.com, Gawker Media, made a conscious decision. They made a conscious decision to expose Terry Boulea naked and engaged in sex and having private conversations in a private bedroom. He was engaged in one of the most intimate of human acts in that bedroom. And they made a conscious decision to expose him in that state to the entire world. This video, which was secretly recorded, which you will hear Nick Denton himself under oath in his deposition described as pornographic and offensive to view in a workplace. It remained on Gawker.com for 6 months. For those 6 months, this man stood there, naked and exposed to the world. Over the course of that 6 months, over 5 million people visited that page. Over the course of that 6 months, over 2.5 million people watched this video. And as it spread virally, as things do on the internet, from Gawker to other places. It began popping up on sites like these. I'm going to read the first one. Hard sex tube, deviant clip, slut. Because of their conscious decision to expose this man naked and having sex on the internet, this is where he ended up. Without his knowledge and without his consent. And that was all because of the choice that the defendants made. 203 days he stood there naked for the world to see. And these people flocked to Gawker's website because A.J. Delario invited them to. His post, when he showed this video to the world, is titled, "Even for a Minute, Watching Hulk Hogan Have Sex in a Canopy Bed is Not Safe for Work, but Watch It Anyway." And they did. As you see from Gawker's own statistics, we're going to be admitted into evidence in this case, what they labeled the Hogan sex tape actual final cut, when it was viewed by 2.5 million people, that minute that Mr. Delario asked them to watch it turned into 439,425 minutes. That's the equivalent of almost 3,083 days that this man was watched without his knowledge and without his consent. When they posted this video, we're going to show you evidence that they knew that he was secretly recording. We're going to show you Mr. Delario's testimony. He knew that this video emanated from a hidden camera. In fact, in the article itself, in Mr. Delario's own words, he says he was secretly filming. Contrary to what you probably hear today, he acknowledges in the article that this is a place where Mr. Delario had privacy while he was naked and having sex. You're going to hear Mr. Delario and Mr. Denton both tell you under oath that when they made the decision to post this video, they knew that it would emotionally distress and cause harm to Mr. Belay. They knew, and they didn't care. They didn't care if it caused harm. In fact, it's quite the opposite. What you're going to see in this case, and what we're going to prove to you, is that they intended to harm him. They intended to harm him, and they intended to use this video to virally market their website. And in the end, they accomplished both of those goals. Now, despite the evidence you're going to see in this case, the defense are going to try to convince you there's nothing wrong. They're going to contend that they were just disseminating news. And the pornographic video that Mr. Delario edited into a highlight reel was newsworthy, a matter of legitimate public concern. Keep in mind, this wasn't a story about what you heard from Mr. Sullivan during jury selection. This wasn't a story about political corruption. It wasn't a story about a mayor smoking crack. It wasn't a story about Lance Armstrong breaking the rules. This was a pornographic video that was secretly recorded without someone's consent, and they knew it. When you see the statements the defendants have made, when you hear their testimony that we're going to play to you in this case, they're going to tell you in their own words that the news was not their motivation for doing this. Their motivation was simple, and it was two things. Gawker, Mr. Delario, they're all guided by Mr. Denton's editorial philosophies and his views. One of which is his desire to level the playing field, to bring down people like Mr. Delario, entertainers, sports stars. It's a power that he needs, he wants. When we talk about power, that really what happened here is what bullying has become in the 21st century. You can even see a glimpse of that when you see Mr. Delario's article. His opening line was that the internet has made it easier for all of us to become shameless voyeurs and deviants. We love to watch famous people have sex because it's something we're not supposed to see. In the wrong hands, the internet that he was referring to is an extremely powerful tool, and it can be used as a tool to inflict harm. In the day and age that we're living in now, the target, it doesn't matter how big they are, it doesn't matter how strong they are. And the reason for that is simple. Because what the defendants have done is they've essentially replaced sticks and stones with clicks and phones. They can sit behind a computer in their offices in New York and attack a man like this by posting pictures of him naked and having sex on the internet.
I'm sorry, can you speak up? I don't know what's going on with sound.
Yes, Sean. Those clicks and phones allow them to be the bully. With a click of a mouse in New York, to be images of him naked and having sex on people's phones around the world. And it's an incredible power. And it's an incredible power that can inflict an immense amount of harm, severe emotional distress. And you're going to hear Mr. Valea in this case tell you about the emotional distress he's suffered. He's going to explain to you what an impact it had on him to end up on websites like the ones that you saw. You're going to see clips of him being interviewed right around the time that this all happened. And you're going to be able to see it on his face. You're also going to hear from Jules Wardle, a publicist who accompanied with him to New York for a press trip that was pre-planned before this all broke, who with her own eyes sat there and saw him cry with Kathy Lee. That's how powerful a tool, how powerful a weapon the internet can be when it's in the wrong hands. The second component, the motivation for this, and intent, is a big part of this case. When we talk about power, when we talk about intent, we're also talking about profit. Because as they were accomplishing the first goal, they accomplished the second goal as well. You're going to hear that the bonuses for the month in which this video was posted for the Gawker website maxed out. Because those bonuses are based on views, the number of people who come to the site. We're also going to show you how they virally marketed They used Facebook and social media to virally market this video, not the story, not the words, this video, to promote their brand and to promote their site. And they accomplished that as well. This is a chart you're going to hear about when Jeff Anderson testifies in this case about the benefit Gawker received from posting this video. This spike that you see in October 2012, immediately after this video was posted, the highest it's ever been. That wasn't for search terms only, for the whole sex tape. It was for their name. When they posted this video, searches for their name, 40% higher than any other topic we've seen. It's exactly what they wanted to accomplish. And you're going to hear that in Mr. Denton's own words. You're going to see it in a memo that he wrote about traffic. This memo. This is his memo to the people that work at Gawker. We all know that some page views are worth more than others. Think of an exclusive. That's a word that you're going to hear a lot during this case. An exclusive, because it has some very serious ramifications, in particular for Mr. Vallejo. An item which gets picked up and draws in new visitors is worth more. So they determine bonuses based on it. Their bonus system rewards sites which recruit new readers, U.S. monthly uniques. And that's because it's the figure that journalists cite when they judge a site's competitive position, and it's the metric by which advertisers decide which sites they will shower with dollars. Traffic means money. That's what we're talking about here. And so what generates traffic? Well, Mr. Denton talks about that as well.
Welcome back. If you know the following brand names like Gawker, Jalopnik, Gizmodo, Deadspin, Jezebel, then you may be curious to see our profile tonight of the man in charge. If none of that rings a bell, then there's a good chance you will know their work. They often give birth to the stories the folks in print and television end up chasing. It starts with the website Gawker, and it starts at the top, a guy named Nick Denton. Recently, Jamie Gangel spent some time with the man who calls himself the gossip merchant.
The stories are so sensational and outrageous, you can't ignore them. Gossip, gadgets, sports, scandal, the blogs of Gawker Media, 8 sites that have become the envy of the internet, and made this man one of the most powerful forces in media. Meet 45-year-old Nick Denton, who says that key to his success is breaking all the rules. Here are the words most often used to describe Gawker. You tell me true, not true. Snarky.
Yeah.
Sexual.
Yeah.
Nude photos as private parts.
If it's interesting.
You report rumors, you don't always check it out.
Yeah.
Shameless.
Yes.
Irresponsible.
Defined by who?
Mean.
Me. Occasionally.
His victims might argue more than occasionally, but Denton is unapologetic. Is there any place you won't go? Is there any subject that's off limits?
I can't be aware of asking that question sometimes, and I don't like to define the answer.
So they pay for salacious scoops, publish rumors, settle lawsuits when they have to, and if they get it wrong, they simply update.
People need to get their head around the fact that the web is different, but we publish faster, we change faster, we correct faster,
And frankly, our standards of publication are low. All the things that never get published and never get broadcast. Those are the stories that we run. We run the offcuts, the things that you're too precious to run.
With a reputation for mischief, Denton has cultivated the image of the naughty outsider, but insists his blogs are really about the truth.
This is going to sound really, really pretentious, but I believe in the larger truth. I believe that the truth is arrived at, often in a rather messy fashion, and that gossip is part of the process, that we'll put out a story and it'll be rough and ready, and then frankly television and newspapers will kind of come and follow on like a day or two later once we've done the dirty work.
That dirty work started a decade ago when Denton moved to Manhattan and launched Gawker out of his apartment. Educated at Oxford, a former reporter for the Financial Times, Denton found young bloggers, paid them $12 a post, and had only one rule: nothing was off limits. What was your vision for Gawker when you started?
That it should be authentic, and it should capture the real conversations, the things that people actually talk about. Our catch line is whatever we know, whatever we think.
His empire is now housed in these trendy downtown offices, complete with a roof deck for parties. And the bloggers have grown up. You over there?
I'm 33, 37.
They're well paid. They get health insurance.
They do.
They get a 401k plan.
They do.
And they're well educated. Harvard, Princeton, Stanford, even this.
Some of us here do have master's degrees in journalism from Columbia. He doesn't really like to brag about that part.
But they still like to promote a rogue image.
It seems that they have just updated the front page.
Within minutes of our arrival, NBC became the target. Oh, that's really unfortunate. You know what? You're going to get no clicks. We're living in the Gawker age, where news is driven by what will draw a crowd, or in this case, a click.
This is the most terrifying thing we have to show you here for traditional journalists, because it's as if every single week is sweeps, and the numbers tell the whole story.
It's called the Big Board, and it displays the second-by-second traffic on all of Gawker's sites. It's a popularity contest, and the bloggers know what drives traffic. Yes, there's a reason for all those cat videos. What do you love in a story, Nick?
I love stories that tell a truth that everybody knows.
Friends are not immune. Recently, Denton received a private email from this friend at NBC, which included a critique of a certain musical guest on Saturday Night Live. Denton sent it to the editor-in-chief of Gawker, who promptly posted it. So let's talk about Brian Williams. He sent you a private email.
Yeah.
And you burned it. Why'd you do it?
I messed up.
No, but this wasn't news. This is a personal email. What kind of person does this?
We publish stuff, we publish stories ahead of maintaining relationships with people without access, favor, or discretion.
So you really don't apologize for it?
For that?
Yeah.
It was a mess up internally, but no, I don't.
Anything for a story, especially one that gets a lot of clicks. Do you care whether people respect you?
I don't need it in the short term. I'm prepared to wait for years. I like nothing better than to be proven right. And I can wait quite a long time for that.
What would you like your legacy to be?
Told the truth, the whole truth.
What would be the snarky Nick Denton legacy headline?
Do Philly's telling the truth? Please.
I'm privileged to be a part of the team that over the course of the next 2 weeks is going to represent Terry Bollea in this case. And I'm going to start out in a minute by telling you a little bit more about Mr. Bollea. But briefly, I would like to introduce the team so that you all have a better idea of who's going to be doing what in the course of this case. Obviously, you already know Mr. Pickell. He's going to question Mr. Bollea, the first witness you're going to see. You'll also hear again from him in closings, and he'll be handling witnesses throughout the course of the case, as will I. Charles Harder will also be handling witnesses during the course of this case. David Houston is Mr. Belea's personal attorney. He's going to be testifying in this case, so he's not representing him as counsel, formal counsel in this trial.
Mr. Joe, can you speak up? I'm sorry, they've turned the sound down so that we can have the White House.
Lisa Merriweather is also here. Lisa's a paralegal with our firm, and she, along with a number of people who aren't here today, have done an incredible amount of work to get us to this point. They're really unsung heroes in the background. They're a critical part of this team. Along with Mr. Daxon with Trial Consulting Services, he's the one who's going to hopefully have all the evidence pop up on these screens and the videos play for you flawlessly throughout the course of this. And he's been extremely dedicated throughout this process. And as I said, I'm honored that we get to represent Mr. Belay in this case. I'm honored to be the person to get to talk to you about Mr. Belay, about how we got here, and about what the result in this case should be. You may remember that on your jury questionnaires on the opening page, it had a caption for this case. The plaintiff in this case is Terry Belay. He's known professionally as Hulk Hogan, but the plaintiff is Terry Belay, the man. And he is a man. You know, the defendants may try to weave them together seamlessly, but he is a man. He's a human being. He has imperfections. He has flaws. He makes mistakes. And in this instance, he's going to be the first one to admit to you that what he did, the situation that he was in with Heather Clem, now known as Heather Cole, was one of those mistakes. He's going to sit right there on that stand under oath, and he's going to own it. Because you're going to learn that that's the type of guy that he is. He's not a guy to back down or shy away when he knows that he's screwed up. You're going to hear Mr. Belay take the stand, and he's going to tell you that he recognizes, he acknowledges that because of the success that he has earned over decades, tearing apart his body in professional wrestling and being an entertainer, that he has to make sacrifices for the rewards that come with that success. He knows that. He understands that. He's going to tell you that. But what he's also going to tell you, in his own words, is that there is still a private side of his life that exists in very few but very important places. That private side of his life, as he will explain to you, is even more important to him because there are so few places where he feels safe and private and where he can be Terry Belay and not Hulk Hogan. One of those places is his home, and one of those places was his best friend's house. Now, his success that we're going to talk about, give you an overview of in this case, celebrity is a very loose term that's thrown around. It comes about in different ways. Some people fall into it. It's not what happened with this man. He was raised just over the Gandy Bridge in Port Tampa in a low-income neighborhood, very humble beginnings. He was always big, 200 pounds at 12 years old. He was good at sports, so coaches were drawn to him. And his first love was baseball. And he was really good. He was even being watched by scouts. But he broke his arm. And that dream faded away. About the time he graduated from Robinson High School in Tampa, he had become interested in music. That became his second love. He wanted to play in a band, maybe pursue it as a profession. But that lure of sports and athleticism kept calling him back. And he found himself following around the professional wrestlers that were in many ways stars in this area in the 70s. We didn't have huge professional sports teams. And he latched on it. He followed them. He begged them for a chance to be a part of what they were doing. And he finally got an in. He finally got a shot. And he struggled for years, crisscrossing the state in his own car, wrestling in South Florida and North Florida over the course of a week for $25. He made so little money that he couldn't make ends meet. So he went and worked at the port, loading cargo onto ships. He worked construction jobs. But that lure kept bringing him back. And it would happen time and time again. He'd try to make wrestling work, wouldn't make enough money, until eventually he got his big break with Rocky III. When Sylvester Stallone came calling. And he got the role of Thunderlips in Rocky III. And at that point, his ascension started.
Mr. Booth, I'm sorry to interrupt you again. They're trying to adjust the sound levels. I can barely hear you.
Okay.
So if you can speak up, please.
Yes.
I think they're going, apparently the jack to that podium has been damaged on Friday, so they'll come in here hopefully. And
Okay.
fix it. So thank you.
Thank you, Your Honor. In the early 80s, he married his first wife, Linda. It was around that time where WrestleMania started to become big. He wrestled in the first WrestleMania with Mr. T. In the third WrestleMania, maybe one of his accomplishments, in front of over 93,000 people, he body slammed Andre the Giant, a 7-foot, 520-pound man. And all that hard work, all the sacrifices that he had made were finally paying off. And he had a lot of success in the wrestling world. He had 2 kids, broken neck. As you start to get into the 2000s, his body is breaking down. He's been doing wrestling for decades. So his focus shifted a little bit to his kids. Always been a proud dad, always very involved. He wanted to do more for them. So he appeared on a VH1 special, Hulk Hogan Stage Dad. It's a series they were doing at the time, hour-long specials, about him being a stage dad for Brooke as she tried to become a pop star. That resulted in a reality show, Hogan Knows Best. Started in 2005. Ran for a couple of years. That's going to be an issue in this case. You may hear a contention that by doing that show, somehow Mr. Bollea waived his privacy. But what you're going to hear from him is that it was scripted. It was controlled. They only taped at certain times. They only taped in certain rooms. And then ultimately, he got to call the shots. It wasn't real reality. It was scripted. Another thing that happened while that show was filming is that Mr. Bollea's marriage of 23 years at the time started having problems. In 2006, he started having real problems. And in 2007, his wife Linda left. She moved to the West Coast and took the kids. That was a very, very serious blow for this man. As his body was suffering years of abuse from wrestling, his wife had moved out. As he tried to get her back, she was telling him he was too old. He fell into a dark place. He came up on a crossroad, and he briefly took the wrong path. And that's where his friendship with Todd Clem, the Radio Shock Jock, Bubba Love Sponge, comes into play. They were friends. They were best friends. Mr. Boulea was Todd Clem's best man. Todd Clem held Mr. Boulea's dad in his arms when he died. These two shared a bond. Because unlike most people, there was a private side of them that no one else really got to see. That's the connection that those two men had. He's going to explain that to you. He's going to explain why someone like Todd Clem could be such a good friend to him. And it was somebody that he trusted. It was someone that he trusted a great deal. It was someone, in fact, at that time, the only one who he felt safe with. He doesn't have that network of friends like most people have. You know, he had one true friend and one safe place, and he thought it was Todd Clem. And so for years, prior to 2007, Mr. Clem and his then wife, Heather Clem, now known as Heather Cole, who had an open marriage, had been propositioning Mr. Boulea to have sex with Heather. And he had turned it down. Thought it was weird. Time and time and again. But when he hit this low spot in his life, when he was in a dark place in 2007, he gave in to temptation. He's not going to give you any excuses for that. He's going to sit up there and he's going to tell you under oath, that was my choice. I'm not blaming it on anything else. It was my choice. But what wasn't his choice was being recorded. Because he's also going to take a stand and he's going to raise his hand and he's going to tell you under oath that he had no idea that he was being recorded in that bedroom. There's not another witness that's going to get up on that stand in this case and tell you under oath that he knew he was being recorded. That situation, when it happened, was so surreal to him. He even said to Bubba, "You're not recording this, are you?" The response wasn't just no. It was, "I'm offended that you would ever think that I would do something like that to you. I'm your best friend." What he didn't know was that an engineer that worked for Bubba in the Clem's bedroom had installed a camera for it to look like this. You're going to see testimony from this man, Dave Rice, who installed this camera separately from Mr. Clem's main security system. And he installed it here, where this X is, tucked away in this corner above a cabinet, pointed at Clem's neck. Mr. Rice is going to explain to you that there was no way that you can tell that this was a camera. It was recorded. It had lights and it didn't flash. He's also going to tell you that in order for this camera to record, that someone had to go in physically, put this in, and press the record button. That person here was Mr. Clem. So 5 years later, after this happens, after Mr. Boulea has a brief affair with Miss Clem, they had sex 3 times, he's going to tell you that. 5 years later, in March of 2012, stories start surfacing about the possibility of a sex tape. When those stories break, Mr. Bollea confronts Mr. Clem. He doesn't want to believe that his best friend did this to him. And his best friend tells him, I didn't do this. I'm your best friend. You know I'd never do this. By this time, the Clems are divorced. Mr. Clem points the finger at Heather. But because this story was only written, it died out. A month later, another story surfaced. This time they had still pictures from this possible sex tape. And you're going to see Mr. Houston take the stand in this case, and he's going to tell you that he sent cease and desist letters to the website that did that, the Dirty, and they took them down. They took them down. And so once again, the story died. Didn't hear anything about it. It went away. Until Gawker. See, it's not a mistake that the video of Mr. Bollea ended up where it did. It's not a mistake that it ended up in the hands of A.J. Delario at Gawker, Nick Denton's company. See, A.J. had a certain reputation that he had built up at that time. A.J. and Mr. Denton had both built up reputations. Mr. Denton talks about his in an interview in Playboy that you're going to see in this case. Mr. Delario had carved out a niche for himself as he posed in this picture sitting on a toilet with a listening device in a bathroom. It's not a mistake that this DVD ended up where it did. There's a very important reason for that. It's a reason of intent permeating this case. It's summarized best right here. Right here. When you talk about intent, when you talk about motivation, when you talk about people having knowledge of the wrongfulness of their conduct, keep that in mind. Because that's the editorial philosophy that Nick Denton has embedded in Gawker, and is going to explain a lot of what you see in this case. So what you're going to hear is that Tony Burton, who is an agent for Mike Halta, who was in a radio war with Mr. Clem, reached out to A.J. Delario specifically because he was a fan of his work. And he reached out to Mr. Delario because he wanted to send him a tape. They exchanged emails. They talked on the phone. Mr. Burton let Mr. Delario know what he was sending. We wanted to make sure that he was being honest. We wanted to make sure that Mr. Delario would say it was going to be honest. You're going to see this in evidence. You're going to be able to take it back with you. The jury are going to look at it. But you're going to hear testimony. You're going to see Mr. Delario's video deposition. He's excited about making this tape. He wanted to cut it up into a highlight and put it on. He wanted to put it online to share it with the world. He didn't want to tell some greater truth He didn't want to expose any lies. He didn't want to expose political corruption. The whole point of this story, Mr. Delario is going to tell you in his own words, under oath, was that he had the video and he wanted to show it to people. And he also wanted to show it to his coworkers and talk to them about it. When we talk about terms in this case like highly offensive and extreme and outrageous and beyond all bounds of decency in a civilized community, we're going to show you that while they may claim that this was about the news during the course of this case, about something being newsworthy, internally there was a much different conversation going on at Gawker. You're going to see their campfire chats about the time that this story was going to break, that this video was going to be posted. Match all. You're going to see some articles from this case and ask whether Mr. Hogan really had a complaint during sexual intercourse. Talk about Bob and the rest of the personality. Bringing the chair goes back. Make jokes about seeing pictures during intercourse. AJ himself probably got interested. They asked if Mr. Hogan's penis, AJ, was wearing a little do-rag too. This is the man who's going to take a stand in this case and try to convince you that what he was doing when he posted this was news. And he asks if his penis was wearing a do-rag too. John Cook, who became editor-in-chief of Gawker after Mr. Delario left in 2013, you're going to see his testimony too. He's the one that decided to post this picture in response. That's a picture of an uncircumcised penis, which you're going to hear Mr. Cook say was what he thought a penis with a little do-rag on it would look like. He's another one of the people that may take the stand. We're going to show you a video deposition and try and convince you that what they were doing was news. Oh, and then, yeah, here's the final joke, where they want to know if he has silky blonde pubes. This is what qualifies as news at Gawker. This is what they're doing behind the scenes. And after joking and laughing about it, Mr. Delario posted it. He posted the video with the article that you're going to see where he invited the world to come watch. We're not going to show you that video in here. It's stipulated into the evidence. You can watch it in the jury room. The defendants may choose to, but we're not going to. We don't need to. We're going to show you A.J. Delario's testimony where he's going to tell you that he purposely included in 2013, after he took the same oath that he would take if he was testifying live in this courtroom. The reason we're going to show you that is because he's going to testify in that deposition to some very, very important things. Number one, he's going to testify that the existence of this tape was not news. Number two, he's going to tell you that the fact that Mr. Bollea was having sex with Heather Clem was not news. Number three, he's going to tell you under oath that the purpose of this post was not to expose any hypocrisy or lies by Mr. Bollea. In fact, he's going to tell you that he wasn't even aware of any statements that he had made about his sex life. before he posted this video. Well, why is that important? It's important because you may hear something different 2.5 years later in this courtroom. You lawyers give you justifications for why this was newsworthy. And it may be all the things that I just said. Mr. Delario may come in and testify that his reason was all of those things now. Even though in 2013, his testimony was different. And if that happens, then you're going to have to judge his credibility. It's one of the things that you do as jurors. And one of the things that you consider when you do that is bias. And one of the things that we're going to show you in this case is a portion of Mr. Delario's deposition from 2015. And what you're going to learn is that after Mr. Delario left Gawker, after he was deposed the first time, after he testified under oath, that none of the things that they may claim in this trial were actually the newsworthy components of this story. Gawker invested $500,000 in a company that Mr. Delario started to run a new website, and that he operated out of his house. That's a fact that you can consider when you're determining Mr. Delario's credibility and whether he has a bias if he comes in here and takes that stand and his testimony changes. One of the most important things we're going to talk about, and I touched on this earlier, is why. Why did they post this? What was their real motivation? And I want to make something very, very clear at the outset of this case. This case is not about words. It's not about the article that they wrote. Mr. Belay is not here trying to hold people accountable for things that they said. It's about the video. It's about the images. And if they had taken down that video when they got a cease and desist letter from Mr. Houston, just like the Dirty did, we wouldn't be here. But they refused. And you're going to hear Mr. Denton under oath tell you that they refused because it wasn't persuasive. In reality, what we're going to show you through the defendant's own statements, through their own actions, through their own testimony under oath, is that the reason that they posted this and the reason that they kept it up is power and profits. They wanted to inflict harm and they wanted to make money. I want to talk about the line, because another big issue in this case, the one that you just heard the instruction on from Judge Campbell, is the line. It's newsworthiness. It's legitimate public concern. And one of the things that you just heard when Judge Campbell was instructing you about the law that applies in this courtroom when you decide this case, is where that line is drawn. It's drawn where the publication ceases to be the giving of information to which the public is entitled and becomes a morbid and sensational prying into the private lives of others for its own sake, with which a reasonable member of the public with decent standards would say that he or she had no concern. That's the line. That's the test. But when we talk about this concept of power, about Mr. Denton, wanting to write his own rules, call his own shots. You're going to see from this tweet from Mr. Denton that he wants his own test. His test is just whether it's true, and it's interesting. That topic came up during jury selection as well, because there's some problems when a standard is just whether someone considers something interesting. That's why the law is different. So you consider in this case whether posting this video crossed that line. Look for statements like the ones in the opening line of Mr. Delario's article. A morbid and sensational prying into private lives. Come watch Hulk Hogan have sex, voyeurs and deviants. We love to watch famous people have sex because it's something that we're not supposed to see. Doesn't sound like something to which a reasonable member of the public with decent standards would say they're entitled to. Sounds like quite the opposite. Their second motivation is money, profit. And you're going to see, we've already talked about Mr. Denton's memo, where these are the types of stories that they prize. These are the types of stories they love. Because advertisers will shower them with dollars. Unique visitors. And so what he wants writers to do is to be even more provocative and more of a hustler so that stories can break out on Twitter and Facebook. Viral marketing. This video, you're going to hear from Gawker's own expert in this case, Peter Horn, was viral marketing. We're going to show you some of his testimony during our case from his video deposition. And he's going to explain to you how this was viral marketing, how they use Facebook to generate traffic. And when you talk about a right of publicity claim, when someone uses an image of another, so as I was saying, these types of stories are the bread and butter for Gawker. And even in the context of talking about knowledge and intent, what we're going to show you is that Gawker, across its websites, knows that posting images of people naked and having sex is wrong. This is what Gawker says out here. You're going to see a story where someone took pictures of public restroom of people and they found their way onto Tumblr. Jezebel, Gawker's women's issue site, wrote a story about how Tumblr refused to take pictures down. What gives Tumblr should be taken down for a violation of people's privacy. You're also going to see stories about people using security features to take people's new photos. Photographs that were mistakenly made public, posting those online is wrong. Don't share or steal people's private things. Maybe an opinion to the internet, but ask people to be decent. despite the law. And when you say it's their own fault,